Pronouncement of judgment, item 1.
Writ petition allowed, impugned order passed by the campus.
May I please, Your Lordship? May I please, Your Lordship? Lordship, item number supplementary, item number 42. Some typographical mistakes are there. I may kindly be allowed to rectify the same to the Lordship.
What's that? What?
Say for example, in page number 240 of the petition WBC, it's written erroneously written as annexure A22. It should have been only 22, annexure 22. Only this much. I may kindly be allowed to rectify the same
Last
now.
time we have given the adjournment with the understanding that you will argue the matter. Last time adjournment was sought.
Today I am ready for argument for submission, but this may kindly be as because my auntie was serious. No, that's why.
After a week.
Highly obliged.
Adjournment request, if any, from item number 2 to 5. From item number 6 to 12. From item number 14 to 24.
Your Lordships, I beg to mention item number 18 on the daily list. Your Lordship, on the last date of hearing, Your Lordships had posed certain queries for which we have prepared RTI applications for various
What
departments.
queries we have posed?
Your Lordships had, among other things, Your Lordship had asked whether the margin for procurement for medium and small enterprises have been fulfilled, or if there is still some quota which is left.
That was a requirement of 10 years, that 10 years experience. That was.
Yes, yes, Your Honor. Yes, Your Lordship.
That is bad. How that is bad? Otherwise, yes, you are registered as a MSME and everything is there, but how it is bad?
Your Lordship had posed the query, which is why we had applied first. Only some replies are
Weeks.
pending. on.
Yes.
Sure, but to mention item 21, Lordship. We are yet to file rejoinder to the affidavit filed by government, so some more time may be allowed, Lordship.
But then 4 weeks.
Of the Lordship.
May I please, Lordship, with the consent of the respondent, Lordship, I beg to mention item number 26, Lordship, for adjournment, Lordship.
Please say.
Humbly obliged, Lordship. I beg to mention item 28 and 29 of today's daily list.
28 and 29.
Lordship, in item 28, I need to file my affidavit in opposition, Lordship. So some kind time may be granted kindly, Lordship.
What about 29?
Lordship, in 29, I appear for the appellant, Lordship. Now, when appears for the respondent, we have 4 weeks. Lordship obliged. I have a similar prayer in respect of item 32, Lordship. Therein, we need to file my rejoinder, Lordship. So some time kindly may be.
32.
32, I need to file my rejoinder. Promotional everything.
Adjourn.
Obliged, Lordship.
May I please, Your Lordship? Your Lordship, I beg to mention item number 27, Your Lordship.
27?
Yes, Your Lordship.
Yes.
May I please, Your Lordship, with the consent of the other side, I beg to mention
27.
item number 40. For
40.
adjournment, yes, Lordship.
Yeah.
For adjournment, Lordship, the affidavit in opposition has been filed today. The matter may be taken up some other day, Lordship.
Adjourn.
Much obliged.
May I please, Your Lordship? Lordship, I beg to mention item 33. Lordship, I'm supposed to file affidavit in reply. The Lordships may grant
Who
us,
prevented you?
Your Lordship may grant us 1 week time, Lordship.
Who prevented you from filing the affidavit?
No one, Lordship.
Supposed to file, then they file.
Yes, Lordship. Your
Urgent,
Lordship may grant 1 week time, Lordship.
urgent. 3 weeks.
Much obliged.
If it may please your lordship, I beg to mention item number 35, your lordship. Your lordship, since my senior is due to some personal difficulties, the engaged senior could not make it today, your lordship.
Today he was pressing hard for stay.
Indeed, your lordship, the consideration,
January.
your lordship may please consider a day.
January. Now it will go in there.
Much obliged.
May please, your lordship. Lordship, in regard to item number 9, I'm sorry I could not mention it when the matter was called. Lordship, in that matter, I'm
Which item?
item number 9. I am appearing for the respondents there in Lordship 227. Lordship, I need to file the objection in regard to the application. It is a delay application, Lordship, 242 days. It has been prepared and sent for vetting, Lordship. So 2 more weeks is required. That's why,
Item
Lordship,
number 9, delay condonation.
by the other side.
So what do you want now?
Lordship, can it be taken up after 2 weeks, Lordship? We have sent the objection for vetting, Lordship. It has not reached
You are
the
appealing
file.
for whom?
For the respondent 227.
227. Kill and a counsel appearing for the respondent number 227, create some more time to file response to the IA number so and so, time period for the grant, it's after 3 weeks. Yes,
Deeply.
Any other request?
With the lordship. My lords, in item number 34, we have filed an additional affidavit on behalf of respondent number 3. Same may kindly be called for, my lord.
call for the
Much obliged.
Daily list for orders, item 2.
May I please, your lordship.
yes,
The amended cost title as directed by your lordship has already been filed.
the matter. It is that order which you are complaining that has not been complied with.
Lordship. Lordship, kindly come to page 11, annexure 1.
Sure.
The operative part, lordship, is at page 15.
One is page 12.
Yes.
Yes.
Lordship, here if I may submit, the post of the director in the directorate has been,
Just
my lord.
fine. Initiation, direction was to initiate the process.
Lordship, my lord. And then, my lord, nothing has been done. In fact, lordship, the surprising thing is, this is such a vital department and since 2017, my lord. When the then director,
Then what happened? Then I think so you have filed a contempt petition earlier also,
my lord,
and contempt petition was filed earlier also.
yes, my lord,
What
and
happened is that?
lordship, because in the earlier writ petition, no specific time frame was given, therefore the honorable court granted 2 months time.
Then now still they have not done.
Not done. In fact, in between, they came up with a review petition and the respondent number 2 filed his affidavit also in the contempt, saying that because we have filed a review petition, therefore we cannot proceed with the selection procedure.
That
That was rejected, lordship.
Lordship has dismissed the review petition. Lordship has said that the government wants to make some amendment by the directorate. The government is free to do that. Lordship has observed that. Government wants to bifurcate the Directorate of Geology and Mining. So government, Lordship has said that this particular order, Lordship's direction is not an impediment to do that. Government can go ahead. Here, in this contempt case, the amended cost title has been given on 14/11, and Lordship, there is an office note on 19/11. The cost title has been corrected. Possibly to the newly implemented respondent, notice has to go at this stage.
newly imputed respondent, who is the newly?
One and two, my lord.
Who are the newly?
Mr. Ajay Tiwari and Mr. Pranjit Kumar Wari. There is an office note, kindly see on 19/11, 19/11.
Tiwari and
Pranjit Kumar Wari.
you are appealing for whom?
I am appearing for the earlier officers who are there.
You are supposed to appear again from them.
This is the content matter, I personally name is there.
Don't go by these or formalities or technicalities. Please.
I mean,
Then take the change is then. The newly added respondents will change, take a new stand in the contempt petition.
I may be given some time from the newly implemented respondent. I will have to take the instruction. Kindly give me some time.
And the earlier respondents have already filed their counter.
Lordship, the respondent number 2.
Respondent number 2, we filed the counter. At that point of time, we said that we have preferred the review petition, and because the review petition was pending at that time, and they said
When this review petition was dismissed.
it is in the month of June,
Where
on
is that,
6th,
order of the.
I have order with me. One item.
Now what you are proposing?
After this order, what steps they have taken, kindly give me some time. I'll get the instruction.
This is absolutely in contempt petition, we are taking it so lightly since
Lord.
the newly added respondents have been, the officers have been changed. The state government, the position of the state government can't be changed. Because the officers have been changed.
I'll obtain the instruction. After, before the,
As per the official report. Amended cost title increase, substituting the respondent. One and two, substituting the original respondents. In the contempt petition. Has been filed. Is noticed that earlier. Shri Arpan Senkia was posted as additional secretary to the government of Assam Mines and Minerals Department, Dispur. And now Mr. Ranjit Kumar Veri is holding the said post. It's stopped. Means the officers who have been substituted in place of original respondent number 1 and 2 are holding the charge, are now at present working as additional chief secretary, Government of Assam Mines and Mineral Department, and additional secretary, additional chief secretary and additional chief secretary, and additional secretary to the Government of Assam Mines and Mineral Department. The strength of the newly added respondents or substituted respondents cannot be different from the earlier respondents. Mr. Dina, appearing for the original respondent number 1 and 2, is directed to accept notice on behalf of the substituted respondent number 1 and 2, and is granted 2 weeks time to file response to the contempt petition, with this understanding that no further adjournment would be granted. He has also been changed. Respondent number 1, 2 and 3 designation.
Look,
File your reply.
three, my learned friend is appearance. For 3.
Yeah, Mr. Nayak is appearing, and this file your response positively by the next date of it.
I'll file.
What to wait?
Item 3.
May it please the lordship. The interlocutory application is for substitution of deceased appellant number 2. Here it is.
Do you have any objection, madam?
My lordship, objection is that, my lordship, I am for the respondent number 8-1 and 8-3 and 8-2. Miss Srimati Podumi Gori, she already expired, my lordship, prior to the filing of the writ appeal.
Just a minute. So this is appellant, this Dipankar
Yes, lord.
Deka was the original appellant,
Original appellant number 2.
number 2.
Lordship.
And in place of him, now you have implemented as these 3 persons as a
Yes. His wife and son and daughter.
son and daughter.
Lordship.
What about this? That is already 8 legal representative of the respondent number 8 are already there.
Already there, lordship.
They are already there.
My lordship, we are paying for 2 legal representatives. One of the legal representative already expired before the filing of the writ
Out
appeal.
of 4.
My lordship.
So how it must fix that? The interest of this disease has already taken care of.
Lordship,
Okay.
but they are also part of it.
The matter comes upon for consideration of the application preferred on behalf of the concept of the appellant for substituting the appellant number 2 through his appellant number 2 by his legal heirs, because the appellant number 2 expired when he was expired.
Lordship on 28/4/23.
Don't have any objection. The counsel for the respondents has no objection if the application allow. Hence, the application has allowed the legal representatives of appellant number 2 taken on record. The amended cost title already filed.
No, lordship.
Amended cost title will be filed within a period of on the list. This list connected with appeal
For admission.
for admission in January
Obliged.
2025.
Item 4.
May I please, Your Lordship? Lordship, we have filed the affidavit, my lord, after paper publication, my lord.
Petition you have filed?
Yes, my lord. Affidavit I have filed.
This court was ordered dated 11/11/2024 has granted time to the counsel for to the appellants to serve the notice upon the respondent, the sole respondent,
Yes, my lord.
sole respondent to paper publication. An affidavit is filed on behalf of the appellants on 19/11/2024, stating that the address of notice upon the sole respondent through publication has been affected by publishing a notice in the two newspapers, two local newspapers, namely Assam Tribune in bracket English and Dainik Agradut in bracket Assamese. Stop. Having heard the learned counsel for the appellant and after going through the content of the affidavit, we are of the view that the service of notice upon the respondent is complete. With this matter for admission, this writ appeal for admission after. We are connected with appeal for admission, writ appeal number 10/2024 after 3 weeks.
Highly obliged,
On the month of January, third week of January.
my lord. Highly obliged.
Item 5.
My lord, the issue before lordship is, my lord, whether, my lord, the Leonard single judge could have directed to pay compensation for the government land. My lord, we have also filed the affidavit in reply, my lord, wherein we have categorically
Lordship, before it proceeds, I'd
Take it.
like to make a statement that Lordship, we are appearing for 51.
We speak loudly.
Lordship, we are appearing for 51 of the respondents. However, there are 152 respondents. Lordship, may I kindly peruse the order dated 21/8/2024, wherein Lordship may see that one of the counsels has stated that the respondent he is representing on behalf of 1 to 150, Lordship, the respondents. However, Lordship, it may have been inadvertently recorded. Lordship, they have filed wakalatnama only for 14. We have filed for 51. And there are remaining 50, around 60 respondents, Lordship.
Madam, that service is already complete.
Lordship, that was probably inadvertently recorded, Lordship. It was not in the wakalatnama.
that is the submission made by the council, my lord.
Probably it could not have been made since they did not find any wakalatnama. And as a result of that, notice could not be issued on all the other respondents, Lordship.
File for whom?
That's all. I don't know, 14 probably.
Only one.
Only 14. Out of 150 to 14.
Let them say they have made the submission.
I don't know.
You are appearing for 1 to 51
I'm appearing for 51, Lordship.
only.
Only 51. And the person who submitted it, he probably has filed wakalatnama only for 14.
Only for
1-4.
who is filed local?
Probably your
And you are appearing for 51.
Yes, Lordship.
So whatever it may be, the cause of all the respondents is one and the same.
Not just for one respondent, Lordship, 51 of the respondents. There are 152 respondents here.
Whatever it may be, but all the respondents are having the same cause.
Lordship, true that. But we have not received a copy of the appeal memo, Lordship.
You are in receipt of copy of the appeal?
Yes,
Look here. Mr. So is appearing on behalf of the respondent number 1.
20, 21, 25, 66, 68, 72, 89, 93, 117, 140, 142, 144.
But reply is filed on behalf of the respondent number 1, 20, 21, 55, 68, 69, 93 and 114.
Maybe contradictory.
Yes, 117, 140, yes.
This. You are not sure how many respondents you are representing.
I think I post it for without the. I'm
So at least you should aware. So now why you are not appearing for all the respondents here?
Maybe that otherwise the matrix said he was appealing, my friend was appealing from 2017 for all the respective.
Now, now in the readable, some of the respondents have not contacted us. So that is the.
Lordship, they're probably appearing for 14 of them. 51 are with us. There are 80 more respondents, Lordship, to whom the notice has not been issued, Lordship.
Maybe my Lord expert also.
In the acceptance, no.
He said that petition to file for
The issue involved in this writ appeal is whether the persons who are in occupation of the government land as encroachers are entitled for compensation in lieu of temporary acquisition of the land by the railway authorities. So, this court, while issuing notices on 21/8/2024, has stayed the effect and operation of the impugned law passed by the learned single judge. On 21/8/2024, Mr. J.C. God Advocate has accepted the notices on behalf of respondent number 1 to 50. And government advocate accept notices on behalf of respondent number 151 to 153. And therefore, this court has recorded that the service of notice upon the respondent is complete. Today, Mr. J.C. God has submitted that as a matter of fact, he is not appearing on behalf of all the respondents, all the respondents number 1 to 150, and is appearing for few of the respondents. Ms. So submitted that she is appearing on behalf of the respondent number 51. Stop. It is contended that the service of notice upon all the private respondents has not been completed. With it as it may, having gone through the impugned order as well as when taking into consideration the controversy involved in this matter, we deem it appropriate to admit this writ appeal, hence admit, issue notice. As the private respondents are in big number, the respondents, the appellants are directed to get the notices upon the respondents served through paper publication by publishing a notice in the local news, the two local newspapers within a period of 4 weeks. 4 weeks from today. Interim order passed by this court on 21/8/2024 is made absolute till final disposal of this appeal.
My lord, may I pray, my lord, that the records of the WPC 6884/17 may also be, my lord, tagged along with the records.
That you first get the notice of them.
My lord.
Item 6.
Yes.
May I finish the lordship? Lordship, I am praying for further 7 days time, my lord, because I have received the instruction.
On behalf of whom?
My lord, respondent, my lord. Respondent number 1, my lord.
Respondent, what about the other respondents?
I'm the respondent number 3.
Respondent number 3. How many respondents are there?
It does, eh?
There are 3 respondents.
3 respondents.
1 and 2 I am appearing.
Who is appearing for respondent number 2?
2 I am appearing. 1 and 2 I am appearing.
And 3, I think, yes.
Okay, Mr. So-and-so is appearing on behalf of the respondent number 1 and 2. Ms. So-and-so is appearing on behalf of the respondent number 3. Learned counsel appearing for the, you are supposed to file, madam, you are supposed to file reply or not?
We've already filed. Lordship.
You have already filed.
Yes.
Respondent number, concept for the respondent number 1 and 2 takes some time to file. Counter to the writ appeal, time paid for is granted. How much time?
Only 7 days, man.
Just after 3 weeks for admission.
My lord, there was undertaking given by my learned friend on the first day, my lord.
That we are maintaining, madam. Yes, sure.
Item number 7.
May it please your lordship. On earlier occasion, government had support to file their affidavit, lordship.
Yes, Mr.
I was supposed to
You
do
are
my
supposed to, compliance of the order.
My lord, the total amount if taken for the whole period was somewhere around 64 lakhs. 41 lakhs something we have paid, that is admitted. The rest of the period, I have got reports from the director and the secretary. There was a liberty to us to find out whether she had actually discharged service or not. Now, what has come up now is that the headmaster, conniving with her, had given her certificates of attendance for a certain period. We are seeking a liberty just to identify whether it is actually a connivance as we have found out in the preliminary inquiry, or she's entitled to
How
the.
much time you want to comply with the order? That's the only.
Otherwise, my lord, the admitted period, we have paid the salary, she's getting her regular salaries now.
If any dues, get the, whatever you want to get the verification,
My lord,
verify, and then in how much time you.
Lordship would having on the first week of January, my lord, we'll have to take the evidence of all the people.
Okay, by first week of January, you'll do that.
We should be able to do.
Okay, Mr. R. Majumdar, the council appearing from the respondent number 1 and 3 has submitted that a substantial due amount has already been paid to the contenders. However, the remaining amount is to be paid after verifying the details submitted by the petitioners. And in that process, some time is being consumed. Therefore, he prays that the matter may be listed in the month of January. By that time, the order passed by this court would positively be complied with. Now come with the date, which date? At the request of Mr. R. Majumdar, list this matter on
The 9th, my lord? 9th, my lord?
9th of January.
9th of January.
9th of January.
My lord, we'll verify if it is not to be, if we find it is not to be paid, we'll bring on an affidavit.
Whatever it may, verify and clear the dues. If any person is entitled, pay. Not entitled, don't pay.
We'll let. Oblige.
Item number 8.
So there is a delay of 54 days in preferring the repeal laws.
Item number?
Item number 8,
Eight.
respondent number 1 is 12.
Firstly, upon the respondent number 2 has not been received.
So they have appeared.
I appear for the private. That's one.
1 to 10,
1 to 12.
1 to 12.
Yes.
What do you want to say?
Insofar as the delay of 54 days to lordship, there was another aspect, my lord. As against the same judgment, the Union of India had itself preferred an appeal. That has already been disposed of in the Aizawl bench by another division bench.
That was prepared by Ministry of Defense also. They have been, direction was given to them, they filed a appeal stating that they are not liable to pay. Ministry of Home Affairs is liable to pay. That was the
Ministry of Home Affairs were party respondents number 17 onwards, my lord. But 17 to 19 were the Ministry of Home Affairs and they were represented.
This is appealed by the Union of India,
the Ministry of Defense.
Ministry of Defense. So how you are agreeing with this?
Lordship, this direction was given to the Ministry of Home Affairs to pay the compensation. And the land was, as per the allegation of the petitioners, lead petitioner, the land was occupied by the different paramilitary forces which are managed by the Ministry of Home Affairs.
So what's wrong in that?
Lordship, they prepared that they are not, Ministry of Defense is not liable to pay compensation. That was the,
That has been clarified by the.
yes, clarified by the division bench. And before that, we preferred the writ appeal before this honorable court, Lord.
So now if the clarification is already there, what remains in this writ appeal?
No, Lordship, because we are challenging, because the petitioner failed to prove that their land were occupied by the armed forces, Lord. And on the only presumption, the order was passed. Other lands, I'll submit before Lordship at the time of admission of the petition.
And on the delay.
Lords,
The matter comes upon the consideration of the application of the filing limitation with the- where to convert the delay of 54 days in filing the connected appeal. So, the respondents are duly represented through advocates. Having heard the learning concept of the parties and after going to the contents of the application, we deem it appropriate to allow the application. Hence, the IA number so is allowed. Delay of so and so days in filing the connected date appeal is condoned. Registry is directed to register the appeal and visit for admission after 4 weeks.
much okay.
Right.
Item 10.
You are appealing for respondent number 5? What do you want to say? The matter comes upon for consideration of the IA number so with a prayer to condone the delay of 69 days in filing the connected appeal. All the respondents are represented through respective advocates. Having heard the learned concept of the parties and after going to the content of the application, we deem it appropriate to allow this IA. IA is allowed. Delay of 24 days is condoned. Registry is directed to register the connected with the appeal. Is for admission.
Item 11.
Myro, delay of 13 days, your lordship, we have taken steps.
I'm appearing for, 3 to 6, Lord.
What about respondent number 1 and 2?
My lord, we have taken step, but AD card has not been received by your lordship.
Await return of notice of respondent number 1 and 2 for 4 more weeks.
Oblige, your lordship.
Item 12. 12 and 13.
And this IA has been filed for implement of Principal Account General Assam audit as respondent number 6 in this writ petition, madam.
You are appealing for?
I'm for respondent number 1, the revenue department.
I'm for principal accountant general audit, my lord.
You are for?
Principal accountant general audit, my lord.
Which respondent?
Respond number.
6, ma'am, now they will implemented as respondent 6. Copy I have served by name transfer.
Okay. The matter comes upon for consideration of the IA moved on behalf of the petitioners with the prayer to impede the
Principal Account General.
Principal Accountant General
Audit.
bracket audit Assam as party respondent number 6 in the writ petition number 5572/2023. So the respondents, the consults appearing for the respective respondents have no objection. The Principal Accountant General audit be included as party respondent number 6 in this petition. Hence, the IA is allowed. The Principal Accountant General audit Assam is included as party respondent number 6. Amended cost rate will be filed within a period of 1 week.
Well,
Mr. So and so accept notice on behalf of the newly added respondent number 6. This matter for admission. This writ appeal, writ petition number 5572 for oblique 2023 for admission after 6 weeks.
Master.
Obliged.
Item 14.
May it please your lordship, there is a petition against the delay, my lord. 493, my lord, this is the old pension, my lord, new pension to old pension, not a single judge, my lord, dismissed the petition, and some of the common judgment, some of it came before the honorable your lordship already passed an order. And last occasion, 2511 also. my lord-
What order we have
Yes, on 2511, your lordship also disposed of the matter.
disposed of?
Dispose of the appeal as well as the.
Appeal itself.
Yes, my lord. The same issue, common judgment, my lord. Flag mark. Government has taken a decision, my lord, regarding.
Yes, sir.
Only delay, but maybe saints, only delay part, my lord, only
Delay.
T20.
Around 600 days. नहीं,
490 pages.
493 days. ये same order.
March. Operation.
Item 15.
No problem. The status preferred is appeal.
I'm appealing for this whole respondent here, my lord. I have received the copy for delay convention today, my lord, today morning. I need 2 weeks time to file my objection, my lord.
Judgment is written
14/5/2024.
14/5. Cannot the delay, you are having any serious objection?
My lord, since I have instruction, my lord, kindly allow 1 week time at least, my lord.
Last opportunity is granted to the learning council for the sole respondent to file objection to the application for condonation of delay. Less after 10 days.
My lord,
Obliged.
I am deeply obliged.
Item 16.
There is a delay of 1 day. Means lordship may issue notice at this stage. No? Okay.
Notice. Registered date just enable 10 days.
Lordship. Obliged.
Item 17.
Maybe the matter will be passed on for the time. The engaged counsel is on leg at court number 7, lordship.
9 months, 6 days.
Regarding condonation of delay, lordship, 9 months.
Next thing. What was the controversy?
Lordship,
The controversy, what was the controversy?
regarding, Lordship,
Before the learned single judge,
Lordship,
what was the controversy before the learned?
prayer was not concerned, Lordship.
Yeah.
Lordship, our prayer was that he had the third child, the cutoff date which was given by the
Please speak loud.
the cutoff date which was given by the Panchayat department regarding the three child policy. It was during that period the petitioner was a pregnant, Lordship. So this was the main controversy. And
With that post of president,
Lordship,
so this post of president is time bound or?
it was time, Lordship. In the last election, he could not contest that particular post due to that particular bar.
So what is this post of this president is?
It's regarding the Kawa Panchayat law.
So is it a permanent post or what?
It's a tenure post, Lordship.
Huh?
It's a tenure post, 5 years.
Tenure post, 5 years.
Yeah.
And this selection took place in which year? That election is already over.
Actually over. But
Then what remains?
but due to that particular bar, in future he could not contest election, Lordship.
That election,
The Panchayat elections.
Panchayat election held in 2018.
That is already completed, Lordship. In the future Panchayat elections, future upcoming Panchayat elections.
Future, so what do you mean by future?
Lordship, the upcoming Panchayat elections.
That constitutional validity of that provision has already been upheld by this court, division bench of this court. What remains in this matter now?
Question maybe the matter may be taken off the part of the consent and responsibility. You could explain that matter.
Pass over the time.
I'll able.
For admission, item 19.
May it please your lordship. May it please your lordship. Lordship, we are here with the order dated passed by the Honorable Single Judge in 7/6/2024, your lordship. Here in the writ, my lord, the conclusion was that the petitioner is not found entitled to pensionary benefits, and the proposal was rejected by the Accountant General of Assam by a letter dated 22/12/2022, your lordship. Lordship may peruse page number 102, your lordship. May I read, your lordship? This is the order passed by the Accountant General, your lordship. 22/12/2022. My lord, here the operative in continuance of the office letter dated so and so, 6/7/2022, I am invited to reference to the letter so and so, my lord, resubmitting pensionary papers in response of aforesaid after regularization of his work charge service from your end, but whether necessary concurrence of the Government Finance Department has been obtained before regularization found not mentioned, your lordship. Hence, kindly provide the order concurrence for early settlement of the case, your lordship. In view of the above, I am returned herewith with the pension papers, including the service book of original, again with the request to resubmit the paper with the copy of government approval order. However, in concurrence with the Government Finance Department has not been obtained. The case may be forwarded to the Government Finance OM dated dispo to 28 December 19, maybe please refer to. Now, lordship, may come to my page number 9 of the writ appeal, your lordship. The grounds on which the conclusion and decision of the learned single judge are challenged, your lordship.
Yes, then what about?
My lord, this is the thing, my lord, here, it was sent directly to the Accountant General, your lordship, without the concurrence of the finance, and it was unaware of the, from the petitioner side, your lordship. Here I am stated in, para 2, your lordship, in page number 9, your lordship. May I read, your lordship?
Yes.
For that the Honorable Single Judge committed a manifest error of the law and fact for failing to appreciate the submission of the petitioner that he has no prior knowledge as to whether at the time of regularization concurrence of the Finance Department of the government has been obtained or not. And point number 3, your lordship. For that the Honorable Single Judge committed a manifest error of law and facts for the failing appreciate submission of the petitioner that the fault lies on the PWD Department respondent authority in not sending the pension papers to the petitioner, though the concurrence of the Finance Department, and instead sending it directly to the Accountant General of Assam. He was totally unaware, your lordship.
So you are not aware that the finance department has granted this, given concurrence or not. But the fact remains that without the concurrence of the finance department, services can't be regularized.
My lord, but he has been regularized, your lordship, but he was not aware of.
By whom? The respondent number 4, executive engineer.
Lordship, that is in page number 47, your lordship.
That's right, but whether he was authorized to do so without the concurrence of the finance department.
But my lord, my lord, he received the regularization letters, my lord, from the department.
That
But-
is not in accordance with law. How can you claim any benefit on the basis of that? You
But-
show us that that regularization was in accordance with law. You'll do that.
But my lord, he got this regularization from the department itself, from the executive engineer PWD, your lordship.
That is what their stand is. That he can't do that. That is what this stand of the respondents. Para number 8 of the judgment.
Lordship.
Read.
Upon consideration of the matters is entirely, the court is inclined to accept the submission made by the Learned Standing Council for PWD as well as the Finance Department to the effect that without prior concurrence of the Financial Department, it was beyond the competence of the Executive Engineer PWD RD Dhakwakhana Title Divisions, Response number 4, to issue an order of regularization service. Therefore, such an order regularization service which was passed without taking a note of Supreme Court order dated Secretary of State of Karnataka versus Uma Devi, so and so, as well as the case of Upen Das, the order under memo number so and so dated 10/2/2022 without jurisdiction and therefore illegal. The said order dated 10/2/2022 would not confer any right to the petitioner to claim pension and other
How
retired
this
benefits.
finding of the learned single judge is wrong? Satisfy us.
I know this regularization of 1 or 2.
How this finding is wrong? Whether we have to, you satisfy us, we will hold that yes, respondent number 4 was competent to do so. But any law on this point, yes, he was competent to do so.
And look, can it be after a week? I'll satisfy you, your lordship.
What remains in this one? Please.
Kindly, lordship, can be after a week? I'll satisfy you, lordship.
Satisfied before the learned single judge also, there was no argument of this effect. Only excuse was that I was not at fault.
Thing is that, my lord, he was not aware of it, your lordship.
So it may be
That he was not even aware, but
which is illegal.
as though he was serving
Whether it
36
confer
years.
any right upon you or not.
My lord,
Any order passed by a authority who is not competent can confer any right upon you or not.
lordship, give me a week time, lordship, I'll satisfy you, lordship. Kindly, lordship.
Ma'am, please be prepared. Next time you come.
Lordship, sure, lordship. I'm sorry, lordship. Obliged.
Item 20.
May please, Your Lordship.
this appeal is for not allowing microbiology applicant to apply for the post of botany teacher in secondary school. And the microbiology.
The Supreme Court has ruled. The non-single judge has relied on the Supreme Court judgment. What's
I'll-
wrong in that?
My lord. But the expert opinion, my lord, could not have been relied on because, my lord, it was a single expert, my lord. Microbiology was not considered, my lord.
You were in the microbiology. What was the requirement?
Requirement was biotechnology,
Biotechnology.
my lord.
And if you are not in that, now you wants that expert opinion should be taken that whether this is equivalent to that or not. This is what your case is.
My lord, the microbiology also should have been prescribed, my lord, as required qualification.
They have prescribed many things.
Bec-
you want
Well,
to
it
be
is,
prescribed,
but
if
because it is also a branch of botany, my lord.
But as you know, the Supreme Court in many of the judgments has already taken this view. In one of the matter, there was a history subject was mentioned. And some persons were having in modern history, ancient history, and they also came that it is a part of that. Wherein the Supreme Court has said if the history is mentioned, then overall, all the subjects are required to be passed. Not in a particular stream or particular subject out of that history. That judgment is already there.
And my submission this, my lord, this expert opinion does not consider the whole aspects, my lord.
That's all. This is the appeal is filed by the appellant being agreed with the judgment and order dated 12/11/2024 passed by the learned single judge in writ petition number 5725 public 2024. The appellants the appellants has approached the Red Court with the grievance that they are having a postgraduate degree in microbiology, but the respondents are not considering the same equivalent to the MSc in biotechnology in bracket plant biotechnology.
My lord, it is botany, my lord. Botany.
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 The required qualification prescribed for MSc in botany and MSc in biotechnology, plant biotechnology. And you are, what you are having?
Microbiology.
Microbiology. क्या लिखा है एक मिनट वापस से बता। In botany or MSc in biotechnology in bracket plant biotechnology.
My lord, may I clarify? My lord, biotechnology has been prescribed as required qualification for botany. Microbiology is not.
That is what we have mentioned. Here. It is contended that the requisite qualification for the purpose of recruitment on the post as postgraduate teacher in subject botany is MSc in botany or MSc in biotechnology in bracket plant biotechnology, but the respondents have illegally not considered the postgraduate degree of the appellants obtained in microbiology equivalent to MSc in botany and MSc in biotechnology. The respondents have contested the stand of the appellants before the learned single judge. The learned single judge, after hearing the counsel for the parties. While relying on the decision of the Honorable Supreme Court rendered in Indresh Kumar Mishra and others versus State of Jharkhand and others reported in 2022 12 SCC 42 has dismissed the writ petition by the impugned order. The learned single judge has opined that the postgraduate degree in microbiology possessed by the applicants cannot be treated as equivalent to MSc in botany or MSc in biotechnology, plant biotechnology, in bracket plant biotechnology. And a counsel for the appellant has failed to persuade us to take a different view as has been taken by the learned single judge. Hence, we don't find any merit in this writ appeal. The same is therefore dismissed.
Item 22.
Let notice go.
Is your lordship.
Yes, Mr.
Let notice go, my lord.
Why you are responsible?
Lordship, I'll pray for interim lordship.
What interim, ma'am?
Yeah. Pending disposal of this petition for provide, because 93 children are there, which in our petition we have below the age of.
By interim, hey, let them come with this, their reply that they are providing or not.
Yes, sir.
Because you said they are not providing anything, let them find their counter. Then
Yes,
only will pass an order.
But-
As an interim measure, how can we pass?
Well, I'm taking notice on behalf of 1, 4 and 6, man.
And other.
Because it's a violation of section 4, 5 and 6 lordship of the National Food Security Act.
All the respondents are represented through their councils.
My lord.
Make it sure. Make it sure.
Yes, my lord.
Social welfare standing on the thing. Social welfare standing on the.
Women and children.
Yes, ma'am.
You note down this. Because by way of this writ petition, the petitioner, by way of this PIL petition, the petitioner has raised the issue regarding
Contract is standing on the contract. Yeah.
non-availability of basic facilities as per the Integrated Child Development Services scheme to the residents of two resettled villages, namely Deka Basti and Pagla Basti, under ward number 5, PS Lumding, Nakuti Outpost, district of Hojai, Assam.
1, 4, 5. 1, 2, 4, 5.
It is contended that
1, 2, 4, 5.
the residents of the said above referred villages, particularly the children, are not getting the benefits of the Integrated Child Development Services in bracket ICDS scheme through Anganwadi centers of the concerned area. Issue notice, Mr. So and so is appearing on behalf of the Respondent number one for consent, please get the details. Who is appearing for whom? The if service is therefore complete, the consent for the respective respondents are directed to file their response to the petition by the next date of hearing. List in the list this petition on 22nd of January.
Deeply obliged.
Deeply obliged.
Item 23.
May I please, Your Lord? The petitioner by way of this PL petition, Your Lordship, has come before this honorable court seeking to.
How this playground is going to be affected by this infrastructure development of 126 schools?
Your Lordship will kindly come to page 92.
92, yeah.
Site plan, Your Lordship. School is in the northern side, Your Lordship.
92.
92.
Yes.
Now, Your Lordship, school is in the northern side, Your Lordship. And they are planned this blue peak, Your Lordship.
Northern side is school. What is that school?
A school building, new school building they are proposing here, Your Lordship. This will destroy the field, Your Lordship.
Just a minute. Proposed school building.
Lordship. New
G1.
Lordship.
This is the
Blue.
open field.
Lordship.
And at present school
Is in the northern side, Your Lordship.
Huh?
Northern side, just opposite side of this, Your Lord. Now, Your Lordship, if they have enough land in that side, Your Lordship.
Which side?
That in the present school premises, Your Lordship. They can construct it, Your Lordship.
You can't dictate the terms of that.
No, Your Lordship.
There is enough land there, so they should construct here and not here.
No, Your Lordship, that is not our case.
Development project here, every development project is going to be challenged.
No, Your Lordship, that is not the case. Your Lordship, why I am here, we are
And
here.
how you are using this playground? What
This
are
is-
the facilities available with that?
Yes, Your Lordship will kindly see. I have stated in my paragraphs, Your Lordship.
Paragraph, you just show us proof, sir.
Yes,
Really open land, and you are saying we are using it as a this school ground and the playground. Playground belongs to whom?
Playground belongs to Your Lordship. It is managed by the school. And Your Lordship, the entire area.
Why the school is not coming and objecting to it?
No, school authority is constructing it, Your Lordship. That's the
They are
problem, Your
having
Lordship.
that.
That's,
They want to construct something.
but Your
How can
Lordship,
you
the only,
object this?
now Your Lordship will kindly see, this is not that, Your Lordship, playground.
The playground, where is the declaration of playground that it is the playground? Any document? It's an open land.
It's since 1944, Your Lordship.
1944 or even since 1844.
Lordship.
It's an open land, government land.
Playground,
It's an open land, government land. It is earmarked
is
for a playground.
Your
Where
Lordship.
is that? Show us any document that it is, this land is earmarked as a playground.
Page 86, Your Lordship will kindly come to page 86.
Yes.
This, in this Borpeta District Sports Office has been organizing this in this playground, Your Lordship, this Khel Moharon, Your
Show
Lordship.
us that it is reserved for playground. Certainly, then they will not disturb that nature of that land. Show us. A open land
Cell
is being
number.
used for as a playground. That doesn't mean that it is effectively it's a playground.
No, Your Lordship,
The
playground,
government has to need some land for the purpose of raising infrastructure.
Your Lordship will kindly see,
Everybody is coming and opposing.
no, Your
don't
Lordship
do
will
this,
kindly
don't
see
do that.
page 82.
You mean to say that the people of the area may not get any benefit of the infrastructure projects? And
No,
they are
Your
not
Lordship,
required?
that is not our case, Your Lordship.
This is what it is.
This is
Yes.
under this playground was developed under MNREGA, Your Lordship. It has been there, Your Lordship. That's why, Your Lordship. And what our prayer is, Your Lordship. We can understand, Your Lordship, that. And মাটিটো কোনো লোকৰ নাই নেকি? Even under RTE Act, your lordship, a playground is must, your lordship, along with the schools. Even under our rules, your lordship, a
Please, you show us that playground, this was the earmarked as a playground and now they are going to change the nature of the land, will certainly.
lordship may kindly then fix it next week, your lordship. We
Get
will
your,
obtain
uh,
this, obtain the
Have you put any-
revenue record, your
have
lordship.
you put any representation?
Yes, yes, your lord, that is there, your
Yeah, decide that representation.
lordship.
Decide that.
One thing, madam.
Yeah.
Para 15 of the petition, madam, the main grievance is there.
Para
They wanted to hold a tournament, the principal is refusing them.
No, that is one of the ground, that's only the fact we have mentioned, that is
Para
not the
15,
case.
Page 19.
petitioner number one, who is petitioner number one?
That is the, your lordship, that was the club, your lordship, and library, your lordship.
Is going to organize a playground.
I could have withhold this fact, your lordship. I have not. Whatever is there, I have placed it before this honorable court, your lordship. If I have withhold it, they bring it by way of an affidavit, then matter is different, your lordship. What is there, I have stated, your lordship.
To whom you have moved the representation?
Lordship, your lordship will page 144, your lordship, that is the directorate, and then district commissioner, your lordship, page 126, your lordship. Oh, that's a-
Who is the authority?
Lordship.
Who is the authority?
It is, your lordship, apart from the school authorities, this is the inspector of schools, your lordship, or the district commissioner, your lordship.
The land vests in the government. It's a government school, amalgamated school, the land vests in the government, my lord. Yes, with the secretary. Records.
Okay, by this PIL. The petitioners have approved this court challenging the action of the state government of constructing a permanent structure RCC building in bracket G+1 in the premises of Hilapakuri Higher Secondary School. Which is that place, city?
Howley, your lordship. Revenue village, Joypur, your lordship, Howley, district Borpeta, your lordship.
In the revenue village, Jaipura,
Lordship, Joypur,
Joypur,
Joypur.
Howli, district Barpeta, Assam. Stop. The petitioner is claiming that the land where the respondents have proposed to raise a G plus RCC building is being used as playground since last more than 50 years. It is also contended that enough alternate land is available with the respondents to construct the new building But despite the said fact, they are bent upon to raise the construction of the new building on the land being used as playground since long. Full stop. On a query, learned counsel for the petitioner has failed to satisfy that the land on which the proposed construction, on which the new construction is proposed is earmarked or recorded as playground in the government records. Stop. It is contended by the learned counsel for the petitioner that the playground was developed with the Narega fund by the concerned local authority and the government of Assam has also organized some sports events on the said playground land. In playground land earlier also. Having heard the learned counsel for the petitioner and after going through the material available on record, this court is of the view that if the respondents are raising some construction over the alleged playground with the intention to improve the infrastructure, the same with the view to improve the infrastructure, the same cannot be interfered with without there being any proof that the land on which the new proposal, new building is proposed to be constructed is reserved for some other purposes, such as playground or park, etc. Stop. With that as it may, it is within the domain of the administrative authorities to raise construction, raise infrastructure over the government land. However, at the same time, if the land is being used for playing purposes or other social activities, since long, the concern of the residents is also to be taken into consideration. The concerns of the residents are also to be taken into consideration. Taking into consideration, taking into consideration the above facts and circumstances of the case, we deem it appropriate to allow the petitioners to move a fresh representation to the district commissioner, Barpeta district, raising their grievance regarding the construction of the new building at the over the land being used as a playground. Over the land said to be used for playground. On making such representation, within a period of 10 days from today, District Commissioner Baspeta After receiving the said representation and after inviting the views from the respondent education department who has proposed to construct the new building shall consider and decide the grievance raised by the petitioners strictly in accordance with law, expeditiously within a period of 4 weeks thereafter. With these observations, Mr. Bole, petition.
Oblige the rules.
Item 24.
May it pleases your worship, my lord. My lord, here, my lord, that the petitioner was, my lord, inducted as Ognibir, my lord. Ognibir, that is, that there is a scheme, my lord, that the Indian youth are given opportunity to, my lord, for induction in Indian Army. Now, my lord, here, but if the impugn order by which the petitioner was discharged from service has page 27. 27. Issued by the commanding officer, my lord. This is small order, page 27.
Yes.
Serial number 2E. Annexure 5, page 27, serial number 2E, my lord. This is the reason.
Released, retired,
Release,
discharged, dismissed.
my lord. Discharged from service for missing training more than 30 days. Under provisions of Rule 13C, Item 4, Indian Army Rules 1954. And as per para 9, as a later, this is their one communication, my lord. Now, the petitioner, my lord, initially engaged, inducted in the Agnibi with effect from 27/12/2022. Then his training started from, my lord, 27/1/2023. And, my lord, he received serious injury during training in his left knee, my lord. And he was admitted by the commanding officer in the military hospital, Kiriki, Pune. For treatment there, my lord, he was released on 13/2/2023, my lord. 13/2/2023. Initially, he was admitted on 27/1. Then he released, he was not recovered. Then 13/3/2023, page 19, Annexure 2, for a period of 8/2/2023 to 13/2/2023, he was under treatment. Thereafter, my lord.
You were admitted in the hospital on?
My lord, initially on 27/1.
27/1.
Yes, he was released on that day itself. Then, my lord.
On the very same day he was.
Yes, yes.
Okay, then?
And next day, my lord, thereafter, while he could not recover, Annexure 2, page 20, admitted on 8/2/2023.
8/2/2023.
Yes, my lord. Release on 13/2/2023, my lord.
Within 5 days.
Yes.
5 days.
Yes.
You remained in the hospital for 5 days.
My lord. By the release order, lordship kindly see at page 22.
22.
Yes, he was recommended for 4 weeks leave, sick leave.
Okay.
My lord, serial number 27, third. Recommended 4 weeks.
This is recommended for 4 weeks. All documents keep in Korea.
My lord. Now, my lord, after the recovery, he was allowed to report on, he reported on duty on 21/3.
21/3.
Yes. And he was allowed to, my lord, join. After allowing joining, my lord, without issuing notice, nothing, my lord, this impugn order was issued, page 27. My lord, now question, my humble submission is that whether The person, my lord,
Is the
period of
order- where's the order
hospitalization.
Whereby you are allowed to join the duty?
That order is not there, but this is the fact, my lord, in the impugn order by the tribunal also.
It is not in dispute.
It is not in dispute. He was, that is the, my lord, tribunal also, my lord, take note of. Now, my lord, question is whether the period of, my lord, medical hospitalization for the injury sustained during training can be constituted as missing, my lord. That's.
This is notice, the tribunal has rejected the claim, this is a appeal against the tribunal's
You have
order.
for-
And for the central one.
So why, this when he entered that he was advised for this leave and he was allowed to join,
Yes.
then why he has been discharged? Sir?
Obtain instruction.
Some reason for it.
And moreover, on the basis of their my lord, own terms and condition for Agniveer, this is not tenable. Leave includes sick leave.
Notice. Want to accept notice on behalf of
All right.
all the this time to file counter today. If petition time for is granted. This. This matter on 27th of January.
Obliged. Because there is no stay order, we cannot pray for. We cannot, my lord, obliged.
Pass over metro 17.
If there is substantial delay in preferring the appeal, there's a 915 days. 916 days, and the reason attributable to the fact that this petitioner, she is from a very remote area and she was not having that required information with regard to the pendency of the writ petition. And when
That's another thing. What is on the merits? When this validity of rule 11A has already been upheld, what remains in this?
No, Lordship, what has happened in this case by the impugned judgment and order, this particular aspect of the matter which has been put to challenge.
Aspect of the matter.
Lordship, this gestation period of 9 months, that was not taken into account while the writ petition was disposed of,
that-
Lordship. Yes, Lordship.
That validity has already been upheld by the court. What remains then?
Lordship, if I take your Lordship to page number 72, Lordship kindly see the page number 72 of the appeal.
Fine. Yes.
Lordship, this with regard to 4.3, this relevant paragraph, so far as the writ petition is concerned,
Yeah.
because several writ petitions were taken into account and accordingly that was all the writ petitions are dismissed.
Ultimately, you are aggrieved by the insertion of that in rule 11, 112.
Yes, 112, Lordship.
Rule 111, subsection 2.
Subsection 2.
So that section, that.
No, we are, Lordship.
That section has already been upheld. The constitutional validity of that section has already been upheld.
Yes, Lordship, constitutional validity, we're not challenging that thing, Lordship.
Then
The reasonable exception with regard to the petitioner is concerned, Lordship, that was not taken into account in view of the provision of 132 of the Panchayat Act.
what is this?
Yes, Lordship, kindly see the provision of 132 of the Panchayat Act. No. I told you. This
Which provision you are referring to?
removal of difficulties, Lordship, 132.
Removal of difficulties, you better say, these are the removal of difficulties.
Lordship, this
question.
basically, Lordship, what has
When it-
happened
Giving
Lordship,
to the provision
on
of the
19/3/2000
action so long. Repugnant the main objective and the provisions of this act.
Lordship, why I'm saying so, because when this particular notification, this amendment came into existence, that was on 19/3/2018. The petitioner, she was already pregnant for a period of 6 months. So
We have gone through the fact and that's why only you are saying you are not able to contest the.
exactly, Lordship. But this is having some ramification in the prospective condition also, Lordship.
Difficulties, how this comes. into
Because the government can
how
take into
this can
consideration.
remove the difficulties.
Yes. Why I'm
Read
saying,
read this section.
If any difficulty arises in giving effect to the provisions of this act, the government may take such necessary action so long as these are not repugnant to the main objective and provisions of this act. The state government may by notification.
Not repugnant to the main objective.
Objective.
And provisions of this act.
Exactly, Lord.
Provision of this act says that after this time.
19
if
2018, yes.
Anybody has given child to an additional child.
Yes,
He or she would be disqualified.
disqualified.
So you mean to say that this provision of the act to be
No,
ignored?
this is with regard to the this specific case of the petitioner lordship. I am not saying it's in general, it's in personam because
They can't do that, sir. If they give you a relaxation, then certainly it would be in repugnancy to the provision of the act.
but the thing
They
is
can't
that
do
lordship, yes, but the thing is that lordship when the honorable single judge while dismissing the writ petition, there is no finding or observation with regard to the specific plea that was raised by the writ petitioner in
So
the.
there is no question of once this validity of that provision itself is upheld, where is the need of the learned single judge to give any finding regarding that, sir?
Relaxation is always there, lordship. Relaxation considering the condition of the
Relaxation provision.
relaxation with regard to the gestation period of the 9 months, lordship, because this lady was pregnant during the relevant period of time.
Whatever the
Yes.
fact may be, yes,
Yes.
we understand, but once the validity of that provision itself is, whereas no such relaxation is given has been upheld, this, the learned single judge has the jurisdiction to interfere with the order, sir.
No, that cannot be done, lordship.
Then,
But the validity, I can understand, lordship, that inconvenience is there, but apart from that validity, the condition that was there with regard to the petitioner, that was never been addressed by the honorable single judge while dismissing the writ
so there
petition.
is no question of why should the learned single judge address, sir, this? Why?
If your lordship kindly see this in order in page number 96, only one paragraph with regard to the fact that for the similar reasons, the reasons were that this particular amendment.
Yes.
Lordship, this is the limited argument on my part, Lordship, because
But now this new elections are going to take place for this panchayat. That's why only you approach this. point.
exactly, Lordship, this prospective effect is always there,
First,
Lordship.
then writ petition was filed, you kept quiet because the elections were over. Now when the new election.
No, Lordship, it's not
now
like that.
you are going to happen, then again you are challenged.
No, Lordship, I'm not with regard to that. The fact is that the dismissal of the writ petition was never been communicated. So after coming to know about the dismissal.
Been communicated.
Exactly, Lordship. This is the reason we have specifically made a mention in our this delay condemnation petition, Lordship. So this, yes, Lordship, there will be limited contention on the part of the petition. Because the division bench order was taken into account and accordingly, your lordship kindly see in the impugn order, the division bench order, the Aisha Begum order was taken into account. And while dismissing the writ petition, even there was no affidavit on the part of the respondents justifying, because in the writ petition, we have, your lordship kindly see the prior portion of the writ petition.
Yes.
In the prior portion, lordship, it's
Yeah.
page number 37.
Read.
37. A writ of mandamus should not be issued directing the respondents to accept the nomination papers of the petitioner for the post of president of such and such, thereby allow her to contest the ensuing general election. As to why a writ of similar nature should not be issued directly to the
That issued now.
lordship.
That
No, I am not on that, lordship. We are basically not challenging that particular amendment of the Panchayat Act. What we are praying
Without
before,
challenging that, how can you challenge this notification 9/11/2018?
no, the impact or the effect of that particular notification, so far as the case of the petitioner, that was actually narrated in the writ petition, lordship. That was never been addressed to that extent, lordship. Because the point that those who were raised before the almost single judge in the writ petition was with regard to the fact that the relaxation is always there. Since the,
Where is that provision of relaxation? You will show us.
because this, with regard to that,
Where is that provision of relaxation? Which is that provision?
because in the writ petition, we have made a mention about this particular thing of 132. But your lordship has
Sorry.
taken a point with regard to that, this is not applicable.
That is your, this argument cannot be accepted.
Now, lordship may fix the matter in the next week, lordship. In the meantime, I will try to justify the points raised in this
But
DDP,
next
lordship.
day, why to waste the time? Okay. The matter comes upon for consideration of the interlocutory application, this interlocutory application under section 5, the limitation with a prayer to condone the delay of 916 days finally connected appeal. The main reason given by the stated by the applicant for condoning the delay is that after dismissal of the writ petition filed by the petitioner by a common judgment and order dated 7/12/2021. Passed in a bunch of writ petitions. She was not informed by her counsel about the impugned judgment. And therefore, and therefore, the delay has been caused in filing the connected appeal. Stop. Having gone through the contents of the IA, we are not satisfied that the appellant, that the applicant has sufficiently explained the delay of 916 days in filing the connected appeal. Otherwise also, in the writ petition, the petitioner, the applicant has challenged the notice dated 9/11/2018 issued by the Assam State Election Commission, wherein it is 2018 issued by the said notice is for information to the candidates who wants to contest the panchayat election regarding the newly added rule 62 in the Assam panchayat rules. The rules name is Assam Panchayat Rules.
Yes, sir.
In the Assam Panchayat Rules,
Amendment. No.
Assam Panchayat, in bracket, Constitution rules 1995. The notice. The improved notice dated 9/11/2018 speaks that in view of the insertion of section 111 in bracket 2 in the Assam Panchayat Act 1994 and in view of the newly added Rule 62 into the Assam Panchayat Rules 1995, Administrative Rules 1995, no candidate shall have more than 2 living children who single or multiple partners can contest the election if the number of children of the said person is more than 2 before 19/3/2018. It further clarifies that any candidate having 2 or more children before 19th of March 2018, if gives birth to another child after the said date, shall be considered disqualified. In the present case, the applicant gave birth to a child.
On 9/7/2018, Lordship.
9/7/2018. It is to be noticed that in the writ petition, by way of it is to be noticed that the petitioner has not challenged the validity of new subsection 2 to section 111 of the Panchayat Act 1994, nor 1994. The learned single judge has taken note of the said fact and has also taken note of the fact that validity of Rule 62 of the Panchayat rules has already been upheld by the division bench and thereafter has dismissed the bunch of writ petitions. Looking to the above facts also, we are of the view that there is no merit in the connected, that on merits also the appellant has no case. In such circumstances, the IA number so and so seeking condemnation of 916 days in filing the connected appeal is dismissed. Consequently, the connected writ appeal is also dismissed.
Lordship, this should be corrected, Lordship. This 9, not 9/7, the 7th of September 2018.
7th of September.
7/9/18.
You got through, sir.
Obliged.
Item 25.
May I please the Lordship? Lordship, we were working as a teacher in various venture schools, Lordship. And some of us were provincialized as teachers.
That division bench judgment.
Yes, Lordship. Yes, Lordship.
It's covered by that.
Yes, Lordship.
Yes, your lordship.
The similar.
Covered matter, your lordship.
Yes, Lordship.
You have passed on similar order?
Yes, Lordship.
Very good.
Lordship, paragraph. Page numbers.
While relying on this judgment, we have passed certain orders. Where are those orders? We are not aware.
Lordship, is that order is at page 674, Lord. Paragraph number 179, Lord.
Judgment dated. The judgment is dated. 410.
410, yes, Lordship.
When a concept of the petitioner has submitted that the controversy raised in this petition is squarely covered by the decision rendered by this court in written petition number 2729/2018, Mohar Ali Sheikh and the others, what says, State of Assam and others. Therefore, and other connected, other connected writ petition, and therefore this writ petition may also be disposed of in terms of the above referred judgment. Learned counsel for the respondent is also in agreement that the controversy involved in this petition is fairly covered by the above referred decision. In such circumstances, this writ petition is disposed of in terms of the judgment dated 4/10/2024, passed in writ petition number 2729/2018, Mohar Ali Sheikh versus State of Assam and others, and
Deeply obliged, Lord.
Item 30.
My lord, on behalf of 1 and 2, my lord, affidavit is ready, my lord. I am going to file it today itself, my lord.
Mr. Manta submitted that. If counter to the restriction would be filed during the course of the day. Let this matter.
My lord.
After 6 weeks.
Item 31.
Yes. Have you filed reply?
Yes, my lord.
Counter to the petition is already there.
My lord.
You have filed counter.
Yes, my lord.
When?
This is already filed, my lord. On 21st of July 23, my lord.
Mr. Sinha, you, on last petition.
Yes,
But file rejoinder.
yes, my lord, the person, my lord, who will file everything, he could not come, my lord, so I could not file, my lord. That is the thing.
How much time would you like? Would you like to? file?
No, just 1 week only. Only 1 week only.
Okay, Mr. Sinha. Then concept of the petitioner pays some more time to file. Reply to the affidavit filed on behalf of the respondent number 2. Time period for is granted. January. 10 January.
8 January. Item 34.
Yes, what happened? What is the progress?
Lordships, in terms of the Lordships last order, I filed the status report. I filed an affidavit today itself, Your Lordships. What has happened is we are trying to do our best. They asked for a supplementary demand budget from us, which we have already submitted. A meeting was proposed to be held with regard to the sanction of 25 crores. yesterday, not yesterday, Lordship, on 30th of November. But unfortunately, it was cancelled at the last minute. Even that I have brought on record.
Then next.
Since then, no communication from the Home and Political Department as to whether, what would be the next date for that particular meeting. Apart from that, the other observations insofar as we were told that we should have meetings with the SBI to have a direct disbursal of the payment, compensation payment to the person concerned, which we have already had. I've also annexed those meetings, and the SBI has also given us.
The matter is under active consideration.
So far as, yes, but then only 9 crores has been sanctioned so far, which has already been utilized. We've also submitted the utilization certificate to the authorities, to the Home and Political Department. So the next batch, which ought to have been.
Today we will see to it. Next week we will take up. Next week.
If Lordship only one prayer, suppose in paragraph 6, they've stated about really about dealing with the 25 crore. If Lordship fix any time period so that can be dealt with, otherwise, well, it again.
Under active consideration. As per the direction they are meeting.
No doubt, madam, they are doing.
Lordship, could I just pray it may not be taken up on 10th or 11th, Lordship, some personal difficulty. Any date after.
11.
Not 10th and 11th. 12, 13.
Okay, January first week may date.
Yes.
8th of January.
DP of letter.
Supplementary list, item 43.
Petitioner challenge the order dated 25/8/2024. Annexa A, page 37. Where the and on civil issue, protected us.
Exactly similar.
High level.
Daily list for hearing, item 36. 36 and 37.
Wait, please, Lordship.
Not to go.
Wait, please, Lordship.
If Lordship would kindly come to page 90. I think your Lordship is holding 318. Writ appeal.
Yes.
Yes. The Lord will kindly come to page 98. This order was put to challenge before the learned single judge. Here is the petition submitted by Mohammad Rabiul Haq, Assistant Environment Scientist, dated so-and-so, wherein Mohammad Rabiul Haq prayed for redressal of his grievances in regard to his promotion to a higher post. Thoroughly examine the records relating to promotion of Rabiul Haq, that is boards meeting, resolution, pollution control, Assam, regulation, etc. After examination of all relevant records files in connection with the matter of promotion of Rabiul Haq, the following are emerged.
Rabiul Haq AES was debarred from promotion for no fault of his own. No decision was taken by the board in its 94th meeting for amendment of table 3, column so and so, and thus issuance of corrigendum was to deprive Rabiul Haq only as it appears. The action taken by the then authority was not in conformity with the above mentioned service regulation, that is 9(3) so and so. Due to the aforesaid reason, Muhammad Rabiul Haq is hereby allowed for upgradation and promotion with retrospective effect as follows. From assistant environmental scientist to environmental scientist with effect from 30th July 2013, and from environment scientist to assistant executive environment scientist with effect from 1st January 2014. Now, my lord, basically what had happened, my lord, the case of the appellant was not considered by the authority. Later on review, my lord, this transpired and this order was passed. Now, before I take your lordships to the other aspects of the matter, I'll take your lordships to the learned single judge's order. Well, with all respect, I'll submit, my lord, the learned single judge has adopted an approach which in effect amounts to, my lord, giving effect to negative equality.
Just a minute, I will look at this, learning, then
So lordship wants me to read the judgment, my lord.
we'll look at it.
Okay. আচ্ছা হেৰিবিলাক ক'ত এই কপিবিলাক ফটো দিবৰ কাৰণে এতিয়া কিন্তু এতিয়া হেৰিয়া ইউটিউবত দিলা না দুটা কপি লাগিব নহয় Mhm. हम्म। ठीक है। हाँ, आगे इस petition क्या तो मैं तो कहूँगी। Very 2385 and 2721. अभी से कहीं कुछ नहीं कोई। हम्म। একটু করি আমার বেলটা বেড়ে গেল।
So basically, this learned single judge, this allowed the repetition on the ground that this 96 board meeting decision was not supposed to be annulled by the chairman of whatever the authority was passed.
And secondly, my lord, the learned single judge totally ignored one thing, that the appellant is the only postgraduate. They are not even postgraduate, my lord. One of them acquired, my lord, that too by distant mode, which was again not accepted by the board. There was no, and my lord, the learned single judge, one of the main reason was in an earlier round of litigation, a different stand was taken.
By the
Yes, but lord, I think the learned single judge should have gone by the regulation. And at 2 o'clock.
Yes.
My lord, in the writ petition, the two petitioners, that is appellant in writ appeal number 318 of 19 and the other appellant, assailed that order whereby, my lord, the benefit which was given to the appellant.
24th of June.
Yes, and apparently, my lord, which has been interfered with by the learned single judge. That is why we are before your lordships. Now, my lord, if your lordships would have this regulation, my lord, I'll prima facie show. I think on last occasion, my lord, we have given the copy of the regulation of 2012.
Yes.
Yes. My lord will kindly come to the regulation 2 Roman 5.
Appointing of the.
Yes, means the chairman of the board or any other officer of the board to whom power of appointment is delegated by the chairman of the board. Then my lord will kindly come to regulation 7.1. Method of recruitment. Appointment to this service under the board shall be made by the appointing authority or by any one or more of the following methods: direct recruitment, promotion, deputation, compassionate ground, on contract. Then my lord will kindly come to rule 9, regulation 9. 931 at page 9. This is very important in this case, my lord.
9(3)(1).
Roman 3(1). In fact, my lord, towards the bottom of page 9.
Yes.
Qualification, experience, and promotion of employees of laboratory and scientific service. For recruitment to the cadre of environmental scientist, minimum qualification shall be master degree in chemical, biological, life and environmental sciences from any Indian or foreign university or institution recognized by Government of India. That means, my lord, the essential qualification required for recruitment to the post of environment scientist is a master degree in the following disciplines. Then my lord will kindly come to next page. B and C, my lord. Promotional criteria for assistant environmental scientist and environmental scientist to higher cadre shall be as per table in appendix. I'll come to this little later, my lord. Now see, all those assistant environmental scientists of the board who possesses the minimum educational qualification for environmental scientist as stipulated in clause A above, or have completed a minimum 5 years of service in the board as assistant environmental scientist shall be brought under the category of environmental scientist along with the post, provided that they acquire postgraduate qualification within 5 years of their service in this discipline stated in clause A. If one is a postgraduate, he can be straightaway, my lord, made, and AES can be made ES. No qualifying service is required. In case of a BSc, it can still be made, but he'll have to acquire, my lord, 5 years, master degree within a period of 5 years. Here I may point out, my lord, Manoj Borua, the other respondent in the other matter, my lord, he could not acquire the qualification, therefore he has been demoted.
After this.
Yes.
promotion,
Yes. So that way, my lord, to that.
petition is nowhere.
Now, my lord, as far as this gentleman is concerned, Hitesh Sharma, he acquired his qualification through distance mode, and board does not recognize it. I'll come here. Now, my lord, please come to the, what is the other mischief which has been done. Now, please come to page number, my lord, appendix 3. The page will be 34, I suppose. Yes. Now, if your lordship would kindly come to serial number 7, assistant environment scientist. So qualification required is BSc, no difficulty, etc., etc. Now please come to 6. Environmental scientist. Now kindly see, my lord, direct recruitment of MSc or promotion from AES with 10 years experience in the ratio of 2:1. My lord, this so-called amendment was never approved. It is the stated stand of the board. Single judge ignores all this. Now, what is the original position? I'll show, my lord.
This, in fact, this has never been approved.
No, my lord. No.
What was the original position?
Original position was, my lord, it has to be, it was a date, no? Now, my lord, can I pass over this, my lord? जनक space को दे दिया.
Yes. This is this is the same.
No, my lord. Kindly see on the extreme remark column.
Yes.
That makes the difference. For promotion, my lord.
Leave it.
Huh?
Here this
If your lordship would kindly have a look at the remark column, my lord.
mark column, in fact, in
At page 34.
environmental sciences, there is nothing mentioned.
Well, on the no, that's why, my lord. Kindly see, my lord, again, serial number, I think it should be 4 or 5.
Yes.
Kindly see on the extreme right-hand column. And now compare it with the one I have given now.
4 says, for promotee scientists, the qualification shall be BSc only.
Now it is not there. Now to clear the confusion, my lord, if your lordships would kindly come to page 241, the learned single judge notices that, my lord.
This is also not approved.
My lord.
This by extreme.
Oh, the original one is approved, my lord.
Huh?
Original one is approved. Now, from the affidavit, I'll show, my lord. Affidavit filed by the board. If your lordship would kindly come to yes, page 125, my lord, is the affidavit. 1 second. Take a copy of the animal like it. My lord, they issued a corrigendum whereby, my lord, they wanted to show that even BSc holders are permitted.
We are a little bit confused.
Yes.
Because we are having 2 copies of these regulations.
Yes.
One is Pollution Control Board Assam Employees Regulation 2012 and another is Employee Service Regulation to the as approved in the 94th board meeting dated 20th of March 2020, 2013.
Yes. Because the other one is draft.
This one.
Huh? No, my lord. The one lordship is holding in the right hand is perhaps yes. Yes.
That is the final.
Yes.
And this was the draft or this was the old draft.
My lord, this position is explained by the board in their affidavit. Please come to page 135. Please come to page 133, my lord. They went by seniority, they did not look for the, my lord. Para 15. That page 133.
Yes.
That as regards the statement made in paragraph 23 and 24 of the writ petition, the answering deponent begs to state that the petitioner, along with other 2, had to complete master's degree in chemical, biological, etc. from any Indian or foreign university or institution recognized by the Government of India as per Regulation 9(3) of the Pollution Control Board, Regulation 2012. But without having master's degree, they were selected for further promotion from the post of environmental scientist to the next higher post of assistant executive environmental scientist as per purported recommendation of the selection committee on 27/12/13. And then the authority also wrongly allowed the same. It may also be pointed out here that a corrigendum was issued on 1/8/2013 by the then authority to legalize the promotion of the petitioner along with two others to the post of Assistant Environment Executive Scientist, that too without amending the relevant provisions, including Regulation 9(3) of the Pollution Control Board Regulation, as well as the columns of Appendix 3 thereof. The said corrigendum was not placed before the board meeting and also not submitted to the government for approval. Amendment of service regulation. As a result, underqualified scientific staff got scope of undue advantage of service benefit in terms of promotion. So this was the stated stand. Actually, they were not postgraduates, my lord. They were graduates. So graduates, my lord, in respect of one of them, there is an express, thing that he was demoted. Now, when it comes to further promotion to the post of Chief Environmental Scientist, then my lord, board resolution is there. Again, in respect of the respondent number 1, that since he is a graduate from, what do you call it? No. Open University, therefore it cannot be accepted. That we have given in our affidavit in reply. Now, if your lordship kindly takes the affidavit in reply, page number 612, that is in respect of the other appellant, and the relevant portion is at 616. First, my lord will kindly come to page 614. In the 104th meeting, this decision was taken regarding acceptance of, my lord, distance mode education.
Yes.
Kindly see, my lord, agenda item number 104.6. The board discussed the agenda in detail, including the Supreme Court order in Professor Yaspal versus State of Chhattisgarh, UGC clarification regarding permission granted to Sikkim Manipal University to open distance education center through franchises, etc. The board observed that Indian Institute of Ecology and Environment, which issued master degrees to two of the board scientists, namely UC Das and MD Odhikari, was never in the book of UGC, and said private institute was found out to be a study center of Sikkim Manipal University. Besides, MSU operated the study center without any approval from the UPSC. Board also noted that the eligibility criteria of admission into said MSc course also included even arts and commerce graduates, which is absolutely in contradiction to the nature of the work in PCBA. It was resolved by the board that for coveted post of SAACES, the candidate must have master degree from a regular university and one should have the experience of laboratory analysis. From the eligibility criteria of the candidates for the said distance education degree, it was understood that the said MSc course lacked the laboratory analysis module. The board took a strong resolution that board needed a scientist to head the laboratory with a regular master degree from UGC recognized university. So, my lord, they do not recognize. Now, regarding, my lord, the other appellant at page 615, item number 104.8.
The other appellant.
Sorry, other respondent, my lord.
That his case is now over almost.
Yes. Okay, that has not come. Now, my lord will kindly come to page number 626 regarding the present appellant. To be precise, at page 627. 27. Huh? I'm sorry, my lord, page 29.
29?
629.
Yes.
A recommendation of the committee. The committee observes that there would be one resultant vacancy in the cadre of SES and there are 6 officers in the cadre of EES for consideration for promotion. Out of these 6 officers, namely Praloy Kumar Das and Hiten Sharma, that is the respondent, do not possess MSc degree from UGC recognized institute, and Sri Karuna Thakuria possesses only BSc degree, hence considered not qualified for promotion as per Pollution Control Board of Assam Regulation so and so. Two other officers, namely, so anyway, my lord, so my lord, board took a clear decision that even the present respondent, my lord, Hiten Sharma, since he does not possess MSc from a recognized UGC recognized institution, therefore his degree cannot be accepted.
For further promotion.
No, my lord, further promotion is okay. Now we are not challenging his promotion in this proceeding. There is another proceeding where we have challenged. But here I am trying to defend my order, my lord. In this proceeding, because there was an order in my favor, which was put to challenge by Manoj Borua and Hitesh Sharma, where the learned single judge interfered. So regarding his promotion, even as my lord environment scientist, which were put to challenge, that is in a separate proceeding.
Yes.
And page 641 is the order, my lord. Now, therefore, my lord, yes, there is one thing which I must say, my lord. The manner in which I was given the promotion, that is one aspect. And merely because I am holding the brief, I will not say. There has to be a review DPC.
It should be. This order, that the pollution control, this AES, that is what, Sir Lalit Singh has not kept it open to again consider in accordance with.
No, my lord, Lalit Single Judge, if your lordship will kindly permit me, kindly come to this paragraph, my lord. Right. Yes.
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 Para number 23, I think so.
Yes, 1 second, my lord. Between judgment to page 233. 318. 233. Yes. The Lord will kindly come to page 241. Or rather 242, my lord, para 19.
Para 19.
Yes.
Yes.
The affidavit in opposition filed by the chairman, Pollution Control Board, Assam, member secretary, etc., is annexure A to the affidavit in reply filed by the petitioner in WPC number so and so. On perusal thereof, it is seen that the stand of the respondent was that name of respondent number 4, 5, and 6 therein, namely Purna Thakuria, Rupamoni Gogoi, and Hiten Sharma, petitioner and serial number so and so, as AES, and as such they were senior to the respondent number 5. Herein, whose serial number was 9. There is no dispute, my lord, that they were senior, but that's not the consideration. It was mentioned that the 96th board meeting held on 5/8/14, the upgradation of respondent number 5 was not approved. The question of further promotion to the level of AEES did not arise. Further stand of the said respondent in their affidavit in opposition filed in WPC number so and so was that persons who have joined board with BSc qualification, their promotion is open to the level of so and so without any preference to MSc degree holders as per rule 9(3)(c) of the service regulation, read with remark in column number 9 of table 3 of appendix 12 of the said table regulation. Further stand of the PCB was that as on the date of filing their affidavit in opposition in WPC number so and so, respondent number 5 was not yet confirmed as ES while he was seeking further promotion to the level of so and so. Thus, on perusal of the affidavit in opposition filed by the respondent number 224 in present writ petition, there is no doubt that compared to the stand of the said respondent in 2721 of 14, there is a marked change in the stand of the respondent in the present writ proceeding, in as much as the present stand, in the present case, the stand of the respondent number 224 is that respondent number herein was the most eligible for promotion to the post of ES A selection committee prepared a list of candidates only on the basis of seniority without considering essential qualification, which is in the violation of the provisions of Regulation 9 of the service rule. It is further stand of the respondent number 224 that for promotion to the post of ES from the post of AES, the provision of Regulation 10 with reference to 9(3) are to be followed by the selection committee. But selection committee constituted as per Regulation 14 did not follow the relevant provision of Regulation 10 during the preparation of selection list. And then authority also did not follow the relevant provisions of Regulation 10. As such, the petitioners along with 2 other AES were promoted to the post of ES in violation of the provisions of the said regulation. Accordingly, the respondent number 224 had justified upgradation and promotion of respondent number 5 with retrospective effect from the post of AES to ES with effect from 37/13 and from the post of ES to AES with effect from 1/1/14. Thus, on comparing the content of the said to affidavit in opposition, it is clearly exposed that respondent number 224 are shifting their stand in the 2 affidavit in opposition filed by them. Therefore, the changing the stand by the PCB Assam is a statutory authority is deprecated. It is seen that although respondent number 224 had been served with affidavit in reply filed on so-and-so against the affidavit in opposition filed by the respondents number 224, where change of 10 was disclosed, yet as the respondent 224 had not disowned their previous stand taken in so-and-so, which was against the interest of respondent number 5, herein cannot be obliterated or wished away. So, my lord, the learned single judge did not make any attempt to find out whether an MSc holder should be preferred or a BSc holder should be preferred. My lord, the stand could be wrong. The duty of the learned single judge was to give a meaning to the regulation, not to find fault in the stand. And by my lord, that means the learned single judge wants that earlier wrong which was committed, that should be continued. In other words, give my lord legitimacy to negative equality. It's very strange, my lord. How can a learned single judge take this view? The previous view was apparently wrong because they went by seniority. And regulation 9(3)(a), it specifically speaks of a postgraduate, my lord.
But this was not exactly argued before the learned single judge.
It was argued, my lord. That was the case.
It is not.
No, my lord, kindly come to the affidavit of the board.
Reflected from the arguments.
No, now, my lord, I'll just place 2-3 paragraphs of the, my lord, affidavit from the board that your lordships will get at page 125.
On behalf of the appellant.
Yes.
What you are now arguing.
Yes.
Okay, even though suppose this order was wrong, whatever the by way of this they have promoted him. This order was wrong and the manner in which the order was passed also not correct. But despite that, the learned single judge should have seen that who is the eligible person for the promotion. But that was not the argument here.
No, my lord, it was not. No, my lord, it was not my writ petition. It was the writ petition of the other side. I was a respondent.
But you have not said that, yes, even though if it is assumed that this order is wrong, despite that, they are not entitled for promotion for so and so reason.
No, no, that's why I'm not calling upon your lordships to set aside their promotion or something. I'm not that. I'm arguing here. I'm standing up before lordships to protect my order only. I'm not saying that the promotion of the writ petitioners are wrong. Therefore, interfere with that. That I'm not saying. That, my lord, I have already said in another proceeding, that stand I'll take there. Therefore, it is not my case that their promotion should also be interfered with. Because one of them has been demoted, he's gone. The other one, my lord, I have challenged that I will take care. এতিয়াহে পাইছে এই বস্তুটো দেখাব পৰা নাই এই ড্ৰাফটখন এপ্ৰুভ হোৱা নাই না তাৰিখৰ মতে কামটো কৰিছে এইটো ক'ব লাগে না কিন্তু নোটটো লোৱা নাই Base 120. Petition to কোন সময় file করেছে? এটা statement যে দিছে 2016 that he is a master degree holder. এটা কোন জনের আছে? Para 3 দিয়ে কইছে he is a holder of MSc degree. No, 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 এটা সব। ভাবিয়েছে আমি তাহলে দিতে কেন কিন্তু করবো না লাগে না নোটিশ প্রজেক্ট করবো রিভিউ বিষয় করলে এটাও না আগে কথা 22 Yes. Yes. My lord, I was placing the judgment. So therefore, what will appear from the impugned judgment is, my lord, the learned single judge took the two different stand taken by the board to arrive at the conclusion that the promotion which has been given is not correct. Learned single judge is right on one aspect, my lord, that I must say, that the manner in which it was given, that is a matter I leave it to your lordship, because I'm always entitled to a review DPC, my lord.
That was the
Yes.
way.
Yes, I'm entitled to review DPC. Now question is, my lord, lordship will see what had happened in this case. Regarding that confusion regarding the, my lord, schedule, my lord. Now please come to page 120, my lord, of my appeal memo. Yes. Page 123, my lord. Now, lordship wanted to find out the difference between, this is the difference, my lord. Page 123. Just to give legitimacy to the promotions, my lord, they made the change, but which was never approved.
Yeah.
The DPC, my lord, yes. Kindly see, my lord, serial number 7, assistant environment scientist. To this extent, it is all right, BSc. Now 6, environment scientist, direct recruitment of MSc or promotion of AS with 10 years experience. Now just come to the extreme right-hand column remark. Now as against 4, for promotee scientist, the qualification shall be BSc only. My lord, this has never fructified. This was only a draft which was never approved by the government, neither by the board nor by the government. Just to, my lord, protect the promotions of this respondent, this was done.
This was done means,
My lord, a draft proposal was mooted, which was not approved by the board, because
on the basis of that draft, they have.
No, promotion was given initially, then, my lord, it was done. And my lord, the board has stated in their affidavit very clearly that neither it was approved in the board's meeting, nor it was approved by the government.
So without approval,
Yes.
without adoption.
Just to give legitimacy to the promotions, my lord.
Now they are defending those promotions on the basis.
No, they never, my lord. Before the learned single judge, my lord, they supported the appellant. That's why the averments I have placed.
No,
The affidavit clearly says, my lord.
But in the earlier petition.
Now, my lord will kindly see our averments in our affidavit. Page number 120. 110, my lord. My lord, this hit and surmise doesn't even have chemistry, my lord. It's not even chemistry.
Yes.
That para 20 at page 110. This was our affidavit before the learned single judge. That as regards to the statement made in para 24 of the writ petition, while denying same, the answering deponent begs to state in connection that altogether, although the petitioner along with 2 others had to complete master degree in a chemical, biological, life and environmental science from any Indian or foreign university or institution recognized by Government of India as per Regulation 9(3) of the Regulation of 2012, while they were promoted as environmental scientists on 37/13 within a period of 5 years, but the petitioners, along with 2 others, did not complete the master's degree within the stipulated time and were further selected for further promotion to the next higher post of assistant executive environmental scientist as per recommendation of the selection committee on 27/12/13. And the then chairman had also approved in a very favoritism, illegal, arbitrary manner in violation of the regulation. It is further stated that to legalize the promotion of 2 petitioner and 2 others to the post of assistant environmental scientist, the then chairman of the Pollution Control Board had issued a corrigendum, that is the one, on 2/8/13, making eligibility of BSc pass environmental scientist without amending the regulation 9C, etc., etc. The said corrigendum was never placed before any board meeting for its approval also. The board did not communicate to the government about the corrigendum during approval of the Pollution Control Board Assam, so and so, so and so. So this is the position, my lord. Now, my lord, kindly see at page, my lord, our writ appeal. If a lordship would kindly come to page 6, my lord, sorry, 5 of this paper book. Page 6, page 5, para 6 is the part of the pleadings in the writ appeal.
Yes.
That the appellant respectfully begs to state that writ petitioner in WBC Hiten Sharma is best qualified candidate and has promoted to the post of chemistry presently designated AES from the post of assistant chemist in so and so along with 6 other assistant chemists. Although the writ petitioner in WBC even did not have chemistry in his BSc degree course. The writ petitioner in WBC had acquired MSc in ecology and environment through distance education from Sikil Manipal, Sikkim in violation of the provisions of the Assam Civil Service Conduct Rule 65. The writ petitioner in WBC has further promoted to the post of environmental scientist by the order dated so and so, and subsequently was promoted to the post of assistant executive environmental scientist by the order dated so and so on the execution of the service regulation as adopted by the Pollution Control Board. It is stated that the appellant had filed any, my lord. This is just narration of facts. Therefore, my lord, what eventually the matter boils down to is I was a respondent in the writ petition. So, my lord, their writ petition was allowed. In my humble submission, my lord, the writ petition ought not to have been allowed because there was no ground actually, my lord. Other than to say, my lord, that order by which the chairman did it, my lord, that I don't say doesn't have that much of legitimacy also.
For the Leonard Singh, even though if we want to interfere with that, then he should have ordered for holding a
Review DPC. And my lord, as far as their promotion, we have already challenged in other proceedings. That will see. My lord, under rule 22 of the Assam rule, the chairman has power, my lord. But then, my lord, with some circumspection, lordships may like to have a look at it, my lord. Rule 22.
I think Leonard Singh has dealt with this.
Huh.
With this regulations have come into force, therefore now the chairman don't have.
Subject to, yes.
Unfettered power. That.
So, my lord, my only prayer is, my lord, at least my case should be considered with effect from the date when my immediate juniors were promoted. Yes, this order which was impugned before the if it was interfered with only on that ground, things should have been different. But my lord, not only it was interfered with, my lord, even the benefit which was given, that was also taken away. On the contrary, as far as the petitioners are concerned, my lord, they ought to have come up with clean hands. They should have mentioned that they've got an MSc degree by a distance mode. And in the paragraph 3 of the writ petition, the averment is a postgraduate. If the averment would have been made that I am a postgraduate from distance mode, then this honorable court, Leonard Singh, would have posed the question. Yes. So in that view of the matter, my lord, my humble submission is, my lord, to the extent of that no relief was granted to the petitioner, appellant, my lord, lordships will take note of that grievance and appropriately deal with the matter, my lord. I think, my lord, I am at least entitled to a review DPC, so that could not have been denied. I myself is saying, my lord, as a counsel, my lord, yes, maybe the manner in which it was given is not that appropriate. Why can you pull them, huh?
Lord, I am appearing for the respondent number 5.
The lordship's kind permission, can I take this?
I have prepared a list of dates. So many facts are there. Probably it may help your lordship.
You are appealing for Hiten Sharma.
Yes, my lord. Lordship has already read the impugned order, which was impugned in the petition, my lord. Lordship may kindly, for 1 minute, my lord, lordship may kindly come to page 90. What was under challenge in the petition?
Para.
Yes, my lord.
Para.
Lordship, page 98, my lord.
Which para you are referring to? Writ petition.
The writ petition, my lord. Page 98. What was before challenge, my lord?
Yes, this is the office order.
Yes, but I'll just read it once again. Already my senior has started, but for my
Oh,
convenience.
sure, sure. Sure.
Payrolls the petition submitted by Mohammed Rabiul Haq, Assistant Environmental Scientist, dated so and so, wherein Mohammed Rabiul Haq has prayed for, well, that may not be related. I'll come to the operative part. Due to the aforesaid, the bottom minor, due to the aforesaid reason, Mohammed Rabiul Haq is hereby allowed for upgradation and promotion with retrospective effect as follows. From Assistant Environmental Scientist to Environmental Scientist with effect from 30 July 2013. Then, by the said order, from Environmental Scientist to Assistant Executive Environmental Scientist with effect from 1st July to 1st January 2014. Now, my lord, by way of the same order, 2 promotions were given. And Lordship will have to see whether on 30 July 2013, whether the appellant was holding the post of environmental scientist or not. Lordship is aware, my lord, a retrospective promotion cannot be given to a person from a date. The person was not even born in the cadre. That is, my lord, settled principle of law, my lord. I'll place those judgments if required. Now, Lordship will see whether to give retrospective promotion, whether Rabiul Haq, the appellant, was in the cadre of environmental scientist or not. Lordship will now come to. Lordship has seen the list of dates, my lord. Lordship will kindly see at the top, my lord, is Hiten Sharma. At bottom, from the entry into service, entry into respective cadre, everything has been mentioned. Lordship, in respect of Hiten Sharma, the entry into service was 31st of December 1994, which is at page 63. May I read, my lord?
Read.
Page 63 of the agreement.
Yes.
Dated Guwahati, the 31st of December 1994. Following personnel working under NAAQM project are appointed as scientific assistant under the board in the pay scale of so and so per month, plus other allowances as admissible from time to time under rules, which effect from the date of their joining. Here, my lord, name at one name is on the bottom, my lord, is the Hiten Sharma. Lordship has got it, my lord. It is the initial entry into service. Then, my lord, next promotion to the post of chemist. Before that, Lordship may kindly turn to page 73. Lordship will kindly mark that page, my lord. It has a relevance to this entire matter. Page 73, my lord. But this is a notification of 17th April 2012. Lordship also will kindly mark that the service regulations, which was there,
Yes.
Lordship,
Page 73.
page 73. My lord, the service regulations, which my senior colleague, has been referring, it was adopted, my lord, which came into effect with although it is of 2012, it came into force on 24th of February 2014. This is the, my lord, notification issued pursuant to approval by the government. Now, my lord, page 73, prior to the coming into force of these regulations, my lord, this notification was issued. Lordship has got it 7th April 2012, my lord. In pursuance to the decision of 98th board meeting held on 3/3/2012, the following posts are hereby re-designated and mentioned below with immediate effect. Earlier, present designation board analyst, senior environmental scientist, deputy analyst, executive environmental scientist, assistant analyst, assistant executive environmental scientist, and chemist has been re-designated as assistant environmental scientist. Now the note below, my lord, in between the rank of assistant environmental scientist and assistant executive environmental scientist, that is, my lord, serial number 3 and 4. The board has approved a post of environmental scientist for direct recruitment of science postgraduate, as well as for promotion of chemist with BSc degree, which is presently not held by anyone and therefore not shown in the table. But prior to the notification, the regulations came into force. Board has taken a decision to create a post of environmental scientist in between 3 and 4. And for that post, the qualifications for promotees were only BSc, only graduate, my lord. Post-graduation was not there. And this regulation, after coming into force, there is a saving clause in this regulation, which has said all actions done prior to that, my lord. So therefore, the contention that only BSc holders will be, because this regulation, in respect of even Manoj Borwa also, these regulations came in, is not applicable because it came into force only after they were promoted, my lord. Now, Lordship will kindly see whether Rabiul Haq was holding the post of environmental scientist on that day or not, my lord.
Yes.
My promotion, Lordship, my next promotional post, Lordship will find at page 69 of Hiten Sharma, my lord.
Nine.
69, my lord. This is the notification, office order of 2nd of March 2007. Lordship has got it.
Yes.
Page 69, my lord. Office order dated 2nd March 2007. In the interest of public service, Sri Hiten Sharma, Assistant Chemist of Pollution Control Board, is promoted to the post of chemist with effect, with immediate effect in the pay scale of so and so. My lord, by way of that notification, Lordship has just perused, my lord, it has been redesignated as environmental scientist. My entry into the post of environmental scientist is 2/3/2007. The regulation was adopted only in the year 2014, my lord. My lord, next promotional post, my lord. My next promotional post is at page 74, my lord. It is dated 30th July 2013. Lordship has got it.
Yes.
Subject to reversion without notice and without assigning any reason thereof, the following assistant environmental scientists of the board are hereby promoted and temporarily and until further order to the post of environmental scientist in the pay band so and so with immediate effect. My lord, on this date also, these regulations were not in force, my lord. Now, his serial number 3, my lord, Hiten Sharma, Lordship has found the name. Now, compared to that, my lord, Lordship, the next promotion, Lordship will find at page 86, my lord. At column number 5 of the table, my lord, I have written.
Yes.
Page 86, Lordship.
86.
Yes.
Yes. This is 3rd March 2014.
Yes, my lord. 3rd March 2014. Subject to reversion without notice and without assigning any reasons thereof, Sri Hiten Sharma, environmental scientist of the board, as per recommendation of the selection committee meeting held on so and so, is hereby promoted and temporarily and until further order to the post of assistant executive environmental scientist in the pay band of so and so, so and so. Now, my lord, presently, after filing of this appeal, he has been further promoted to the post of EES, Executive Environmental Scientist.
But he is taking motion from the date.
Lordship.
He is taking this promotion from the date when he was promoted. So he may get another chance for further promotion. During the pendency of maybe he might have again be promoted.
Yes.
The said post, but
That has been challenged in a separate proceeding, my lord. I am not doing any finding on the effect may Lordship be difficult, my lord. Lordship may now see whether Rabiul Haq, lord of position as regard Rabiul Haq, my lord. Lordship will kindly see Rabiul Haq name is there in the bottom, my lord. His entry into service is at page 68, my lord.
Yes, page 68.
Yes. It is in the table, Lordship. I have prepared the chart, it is there, my lord. Page is mentioned.
Yes. Yes.
It is dated 26 May 2003, subject to discharge without notice and without any reason thereof. Rabiul Haq, who has been serving as so and so, has been appointed as assistant chemist in the board. That is the entry into service. From the date of entry into service also, the appellant is junior to that of the respondent number 5, my lord. Next, my lord, promotional post at page 72. Subject to reversion without notice and without assigning any reason thereof, and pending receipt of approval from the concerned authorities, following assistant committees of the board are hereby promoted temporarily and until further order to the post of chemist in the pay band of so and so. Here, my lord, Rabiul Haq, appellant at serial number 2. Now, my lord, thereafter, lordship may kindly turn to page 84.
Yes.
But this is very relevant, my lord. Page 84. It is an office order of 23rd September 2013. Subject to approval of the board, the post of assistant environmental scientist of the board are upgraded to the level of environmental scientist with immediate effect. Consequent to that, the following assistant environmental scientists are upgraded to the level of environmental scientist. The pay and other promotional benefit will accrue to these scientists with retrospective effect only after approval of the accreditation by the board. Here, my lord, Ranjan Bordoloi, Paramjit Nath, Jiban Sarkar, Manoj Borwa is the respondent number 5 in the other writ appeal, my lord. Rabiul Haq at serial number 6. This was the purport of this communication was that you will be promoted subject to approval of the board, and your pay and allowances will be applicable as with retrospective effect only if the board approves the upgradation. Now, lordship may kindly come to page 90. My lord, this is the order dated 12th of August 2014. Pursuant to the decision taken in 69th board meeting under agenda item number 5, 4 posts of assistant environmental scientists are upgraded to the level of environmental scientists, and the following 4 senior-most assistant environmental scientists are allowed to hold the upgraded post of environmental scientist with effect from their date of joining as shown against their names. The pay and other promotional benefit will accrue to them with effect from the date of their joining as per board office order dated so and so 23/9/2013 that lordship has previously perused, my lord. At the first 4, my lord, there were 7 names, lordship may recollect, my lord, at page 84. 7 names were placed before the board. Board approved only 4 names, my lord. And lordship will see, in view of the board's decision as referred under para, the above para, the post held by the following personnel shall continue to be the level of assistant environmental scientist, and their designation shall be AES only. Here, my lord, at serial number 2 is Rabiul Haq. But this order, the appellant has
never promoted as a this.
He was even not
scientist.
if he was not given the post of environmental scientist, how the appellant would have given retrospective date, promotion from a date he was not born in the cadre of my lord environmental scientist. But this order was never put to challenge by the appellant at any stage, my lord. And thereafter, lordship will kindly see. So he continued on 2014, he continued till the passing of the impugned order. He continued in the level of AES only, my lord. How he could have given retrospective promotion from a date he was not born in the cadre of environmental scientist? That precisely the Raleigh single judge has decided, my lord. And that apart, lordship will kindly turn to page 87 for a moment.
No, what he is claiming that this Hiren Sharma or whatever his name is, and the other person
Yes.
who was later on demoted,
Yes.
they are not entitled for this post on account of that they are not having
This
requisite
is their claim, my lord. This is
Huh?
their claim. Board has in fact approached, my lord, I have filed an affidavit in reply to that affidavit where the Guwahati University has accepted my degree, my lord. Lordship may peruse that also.
distance education.
Yes, my lord.
No,
of the affidavit.
We are not going into all this, so we are simply saying that revisit this promotion exercise again.
Lordship.
Revisit this promotion exercise.
No, my lord, whether that, in that case, if a lordship holds that, lordship will say that the order of the single judge, or with great respect, my lord, if lordship has to hold, then lordship will have to give a finding that the order of the standard single judge, there are some defect in the order. Without going to that aspect, perhaps my lord, lordship may not like to find that, give such a direction, my lord. And secondly, my lord,
No,
whether the second question, my lord,
even though, without interfering in the order of the standard single judge, we can pass this order.
it can be passed, my lord, whether it was necessary in the given facts and circumstances of the case, whether, lordship settled position is that, my lord, I can place the judgment, my lord. Retrospective promotion cannot be given from a date he was not born in the case.
So that's right. No doubt. That's why only without interfering in that order. But what is the rightful claim of the appellant? That can be decided.
Lordship will kindly see, lordship, my lordship, they are defending pay order at page 98. Lordship will now kindly see this office order, my lord. Lordship, before that, my lord, lordship, kindly read page 87 for a moment, before reading to date, my lord. Lordship, page 87 of the appeal memo. What was the stand of the board with regard to the appellant, my lord? May I read page 87, my lord?
Yes.
Lordship, it was issued by the board on 28th of May 2014. It is addressed to Rabiul Haq, who is the appellant before your lordship. Lordship, I'll read paragraph 5. Your representation dated 10th March 2014 and 24 February 2014. You are seeking promotion to the level of Assistant Executive Environmental Scientist as per Regulation 3C of the Employee Service Regulation, which provides for upgradation of the post of Assistant Environmental Scientist, earlier known as chemist, in respect of those who have completed 5 years of service in the board as AES or chemist. Even though you had served as chemist or AES only for above 2.5 months since your promotion, you were favored by allowing to hold the post of environmental scientist by the order of board dated 23rd September 2013, pending approval of the board. It was clearly stated that the promotional benefit will accrue with retrospective effect. The benevolent act of the board has not been appreciated by you, and you are claiming further promotion to the next level of AEES. This is not acceptable. As per Regulation 9(3)(c), read with remark column in column 9 of Table 3 at Appendix 3 of the Pollution Control Board Assam Employee Service Regulation 2012. Those who join the board with BSc qualification, their upgradation promotion is open to the level of EES without any preference of MSc degree holder. Only for the level of SES and above, MSc is the essential qualification. The 3 number of environmental scientists, namely Karuna Thakuria, Rukamani Gogoi, and Sri Hiten Sharma, have been promoted to the level of AEES, depending upon their seniority and suitability. Your possessing MSc degree in environmental management, being junior to the above named 3, as well as 5 others, cannot be considered for promotion to the level of AEES. As in doing so, 8 numbers of your seniors would have been superseded. As per rule, MSc is not the essential qualification promotion from the level of ES to the level of AEES. The board, by allowing you and 6 others hold the post of ES, have given extra favors so that newly recruited scientists are not placed in the cadre list as your seniors. Instead of appreciating the special dispensation granted by the board to you and 6 others, you have been claiming further upgradation to the post in violation of the service rule. Your above appeal petition are disposed of with the issuance of that. With the assurance that you and 6 others will be given promotional benefit with retrospective effect when the board will notify once the order dated so and so. Your claim for promotion to the level of AES is rejected. This is with the approval of the Chairman Pollution Control Board. But a member secretary has issued the communication Chairman has the approval to that communication. My lord, the promotion of to the post of ES was rejected by the board. Now, how the chairman of its own would have taken a contrary decision to the decision taken by the board, my lord? Under the service regulations, the chairman is not the appellate authority of the decisions of the board. There is no provision, my lord. In fact, my lord, on the date when the order was issued, he was not even holding the post of environmental scientist. Lordship, now Lordship, kindly see the document I have given. When he was promoted to the post of environmental scientist, my lord. Lordship, read this with, along with page 98, my lord. Lordship will clarify. At bottom, my lord, at the two, in the interest of public service, Robiul Haq, Assistant Environmental Scientist, is promoted to the rank of Environmental Scientist in the pay band of so-and-so as per month, plus other allowances as admissible under rule in force with effect from the date of taking over charge. It is dated, Lordship, 12th of June 2024. Admittedly, he has joined. Now, my lord, he cannot approbate and reprobate, my lord. Once he is claiming from a date, 2014, when he was promoted in 2024, he has accepted this promotion, my lord. But he has no right to file this appeal, my lord. In my most respectful.
It is of 12th of June 2024.
24. Only
The appeals were filed when?
My lord.
Appeals were filed when?
Appeal has 2019, my lord. Restriction of the. Now,
You don't have any right to file an appeal. Where was the right this?
No, my lord, they cannot approbate and reprobate, my lord. Now, by accepting your.
What is the choice with them?
My lord, he could have joined under objection, my lord.
That's it.
No, but accepting for a moment, my lord, what I'm trying to say, this apparently shows he was not holding the post of environmental scientist on 30 July 2013 as reflected in the impugned order.
That is his claim, apparently shown. What do you mean by apparently shown? That is his claim.
Yeah.
Which is to be decided.
He has been claiming this, he has been trying to defend this order of 2016, 24 June.
That's right. He is only, this order is defending apart from that, the learned thing.
The appellant admittedly was not holding the post to show your lordship that he was admittedly not holding the post of environmental scientist. I'm placing this document. Because lordship will see from assistant environmental scientist to environmental scientist with effect from 30 July 2013. Then from the post of environmental scientist to assistant executive environmental scientist with effect from 1st July 2014. So whether on 1st July 2014 or on 1st January 2014 or on 31st July 2014, he was holding the post of environmental scientist. This is the issue to be decided by your lord. That is the factual aspect. If he was holding, then my lord, I'm reading judgment, my lord, to that effect. But third judgment, my lord.
Yes.
It is 1991 supplementary 1 SCC 334. I have given the list of data. My lord, he is also saying that the regulation has not been approved. He is seeking benefit of the same regulation at one hand, trying to take benefit of the regulation, and at the other hand, they are saying that the regulation has not been approved, my lord.
Yes.
But this dual standard, well, I'm not saying, my lord, that dual stand, my lord, may not be permitted by your lordship. At one hand, they are trying to take benefit of regulation 9(3), and at the same time, they are saying that this regulation appendix has not, they have not challenged the regulation till date, my lord. Lord, you kindly turn to paragraph 12, my lord.
1991 SCC.
Supplementary 1 SCC, my lord.
334.
334.
Yes.
I'm reading only one paragraph, my lord.
Which para?
Paragraph 12. In the instant case, may I read, my lord?
Yes.
In the instant case, the promotee responded number 6 to 23 were not born in the cadre of assistant engineer in the Bihar Engineering Service Class 2 at the time when respondent number 1 to 5 were directly recruited to the post of assistant engineer. As such, they cannot be given seniority to the service of assistant engineer over respondent number 1 to 5. it is well settled that no person can be promoted with retrospective effect from a date when he was not born in the cadre so as to adversely affect others. Here, my lord, on my lord, 30th July 2023, the appellant was not holding the cadre of AEEF, environmental scientist. Therefore, my lord, retrospective promotion cannot be granted, my lord.
Yes.
My lord, the second judgment, my lord, I am relying is my lord 2007-15 SCC 406. Paragraph 16, my lord. May I read? Lastly, the High Court has may I read, my lord? Paragraph 16. High Court has specifically rejected the claim of the appellant on another ground, namely that the appellant were not born in the cadre of ACF on the day which they have been given seniority. We are in complete agreement with High Court, particularly in view of the decision of this court in state of Bihar versus Akuri Indranath that I have already placed, my lord. The same law has been decided, my lord. We do not want to burden this judgment with further repeated decisions. However, the same view has been given in another reported judgment of this court in so and so, so and so. But that view has been taken in this case also, my lord. Similarly, on the third point, my lord, judgment I am relying is 2013 8 SCC 693. Here, my lord, I'm not reading, my lord, paragraph 45, 46, 47, and 48.
Yes.
Four paragraphs, 45, 46, 47, and 48. The same fact has been narrated, my lord, and the same principle of law has been laid down.
Multiplicity of the on very same point.
Yes.
What is the point in giving number of authorities? The law is well settled. Why do
And as regards the scope of appellate court, my lord, this court has decided, my lord, the division bench of this court, up to what section, my lord, the writ court. So people kindly, I'm referring that, my lord. Paragraph 10 and 11. This was, my lord, a division bench judgment reported in 2016 for GLR 643. But the paragraph 10 is not similar to that, my lord. So I'm not reading similar to the other judgment. Paragraph 11, my lord. While considering intra-court appeal, we must bear in mind that a writ appeal is an appeal on principle, and unlike an appeal in ordinary sense, only patent error on the face of record or infringement of settled principle of law can justify interference with the decision of the learned single judge. If two views are possible on a reasonable view is adopted by the learned single judge, the other view, however appealing it may appear to the division bench, should not normally be allowed to prevail. See so and so, so and so. Applying the principle, we find that learned single has not committed so and so. But a single judge has delivered his judgment on the principle of law that retrospective promotion cannot be given from a date the person was not born in the cadre. And secondly, my lord, the petitioner challenged the jurisdiction of the chairman to pass that impugned order. On these two counts, my lord, the single judge has allowed the writ petition. As regards the other part, once they are saying that they are taking benefit of the regulation, and at other hand, they are saying that the regulations has not been approved. But there is nothing on record that regulation has not been, that stand has not been taken by the Pollution Control Board. They are all throughout relying the same regulations, my lord. And in my most respectful submission, my lord, there is no requirement for interference with the order of aspects. In fact, he has already been promoted now as of 2024. So his grievance has already been made up.
he is seeking promotion from 2015
But he was not born in
already been promoted. It's very
he was not born in the cadre on
That's your argument, but now you can't say this grievance has already been redressed now.
No, my lord, he has been given promotion, my lord.
But he's seeking promotion from an earlier date. not
Earlier,
from
he was
this.
not born in the cadre on that position.
Oh, that's right. That is your argument.
Yes, my lord.
But you can't say that now he can't.
No, I'm not saying that, but I'm saying that.
He can't raise that now maintain this appeal
No, but
since he has already been promoted.
No, my lord,
Had he been promoted on the very same date when earlier he was promoted, you can say yes, now he has already been granted. There is no
I
need for.
placed that document only to show that on 30th July 2013, he was not holding, apparently not holding the post, my lord.
Order is up.
I'm obliged.
Item 28.
We take these matters in January. All the other matters in January.